Today's topic will be wrongful conviction. This is part 2. We also need to discuss jailhouse informant testimony, and that's something that a lot of people don't realize. These informants sometimes rush to testify, like, unfortunately, as we call it in the field, vultures. Untruthful or incorrect testimony in these cases can very easily lead to wrongful convictions, especially where there is no concrete physical evidence. Now, according to such places such as the Innocence Project, more than 15, almost 20% of wrongful conviction cases were overturned from DNA testing alone, and an informant testified against that defendant at the original trial. The most common form of informant testimony is what we call a jailhouse snitch, and they're often offered incentives to testify, and that's what becomes problematic here, folks. They might be offered a lighter sentence, withdrawal of a criminal charge, for example, or even money in some cases. And in many past wrongful conviction cases, the deal that was ultimately given to the informant in exchange for that testimony was kept secret from the defense and that ultimate trier of fact. There is a more recent case in the media that you would be familiar with, Guy Palmera, and the jailhouse informant testimony was a key factor in his wrongful conviction. Two jailhouse informants, one whom have been classified a dangerous offender in this case, testified against him, and several commissions of inquiry have made recommendations to date regarding these jailhouse informants. And to the credit of some, many of the recommendations have been followed, and the use of jailhouse informants has been declining, thankfully. One thing I find particularly important to spend a moment on is professional misconduct. And, this refers to how lawyers, perhaps police officers, forensic experts, they all can contribute to, causing a wrongful conviction at the end of the day. And a lot of people don't realize that or take the time to understand how that can happen. Procedural issues relating to how a case, for example, is tried can have some really awful consequences for wrongful convictions. Prosecutorial misconduct can relate to how police and prosecution handle a case, as well as the diligence with which the defense is mounted. So it's a combination of factors here, folks. Now, Innocence Canada has stated publicly that they understand the vast majority of lawyers and police, they act with the best intentions here. As I said earlier, defense counsel can, in some cases, mishandle their client's case. Defense counsel, especially those who have provided services to lower income individuals through perhaps legal aid, for example, they're often overworked. They've got plenty of cases. In fact, they often have a much higher caseload than sustainable otherwise. And so that effect of being spread too thin can lead to some very serious mistakes in judgment. Now, police can also face many pressures when investigating, especially high-profile cases, and they can come from the public, from their superiors, it may be from the media, from the victim's family, from friends. And while studies have really shown that putting more pressure on people can be beneficial and it can increase productivity at the end of the day, too much can have the opposite effect. And that's what we have to be careful of, and that can very easily lead to tunnel vision, which we discussed earlier, and we need to be mindful of. The withholding of evidence from the defense is a good example of professional misconduct by the prosecution. With few exceptions, the accused and his or her counsel have access to all evidence that the Crown has. Now, that includes exculpatory evidence. And a good example in the 91 decision of the Supreme Court, R versus Stinchcombe, the Justice Sopinka held that the Crown had a legal duty to disclose all of that information at the time, and the fruits of that investigation, which are readily available online, are in its possession, are not the property of the Crown for use in securing a conviction, but the property of the public to be used to ensure that justice is done. And that's the key here to remember. If you are looking at cases after the fact, folks, Stephen Truscott is a good one to look up. The Crown did not in that case disclose its knowledge that an individual had been charged with sexually harassing young girls at around the same age as Truscott's alleged victim within that same immediate area. Now here's the thing, guys. In recent years, this problem of wrongful conviction has become a reality, and it's become an accepted reality in a lot of common law jurisdictions. High-profile cases tend not only to draw our attention to these effects of wrongful conviction on individuals, but it also tends to point out how aspects of our criminal justice system have failed. And research has now really demonstrated at the end of the day that a number of factors generally occurring together contribute to wrongful conviction and to imprisonment. They include, as we've talked about, not an exhaustible list, of course, but erroneous eyewitness identification, police and prosecutorial misconduct, false confessions, in-custody informants, and unsound forensic science or its misuse. While the majority of the research has kind of emanated from the US, a lot of the more recent statistics have come from Canadian context. And we can look at that and see how recent research has demonstrated similar contributing factors, right here in Canada as well. Now, one of the topics that people will often reach out to me about is, coping with wrongful incarceration. How do prisoners, people who have spent long periods of time, cope? And the best way to, of course, figure that out and learn about that is to speak with someone who has experienced that personally, of course. Now, the effects of long-term imprisonment have been well documented in literature, and the special stresses especially that affect prisoners include relationship difficulties, as you can imagine, especially if you're innocent. We're looking at a loss of these crucial relationships outside of prison, and problems, of course, in developing normal relationships inside the prison facility. There is a concern with mental deterioration for people with mental health issues, as well as those who develop issues inside the institution. And we also have the issue of indeterminate sentences and the nature of those, and the prison environment itself. We've talked about this in other video vlogs, where the punitive model can be more harmful than helpful. And all prisoners have to learn how to cope somewhat, whether you're innocent or not. If you're put in that situation, you have to learn with the coping, the pains of imprisonment, the impacts of imprisonment, but they appear to go very far. They go beyond those experienced by other long-term prisoners, especially if you're innocent. So these individuals particularly are victims of miscarriages of justice, and that has to be recognized. There are very harmful effects of confinement in general, and that's further exasperated here, folks, by the unjust nature of their incarceration. They shouldn't be there in the first place. So, it's important to explore the coping strategies that people can often, use while they're incarcerated, and that they will often adapt to, especially if they're wrongfully imprisoned. Now, these strategies, including violence, cooperation, withdrawal, preoccupation with exoneration, for example, represent some resourceful means to ensure their well-being in a very otherwise hostile environment, such as a prison. As I said earlier, coping through violence, especially when you first enter the facility, is a big problem. You're dealing with potentially armed groups, different factions, freely walking around, sometimes high, medium, and maximum security institutions, armed, concealing, chemical weapons, fire weapons, bludgeoning weapons, you name it, they appear in these institutions. People have feared for their life in these walls, and have even talked in some cases of making vests, protective vests, out of magazines that they've acquired. stealing duct tape, and creating their own makeshift protective vest. And that's something that we really need to consider. People are having to wear these under their clothes every day, every time they leave their cell, for fear that something is going to happen, and that is just not acceptable. The other big issue is withdrawal and isolation inside these facilities. Now, there's been suggestions that withdrawal, which can take a number of forms, that is an important prison coping strategy. Now, that can manifest as physical separation from other prisoners through segregation. It might be isolation and minimal communication with other inmates. That conscious withdrawal from a prison population can sometimes help a prisoner maintain that sense of sanity, or because that person may have felt like they were inherently different than the other inmates. And that can happen quite often, as you can imagine, if you are living inside these walls, inside our institutions, and you're innocent. Another coping strategy that appears to be fairly popular and particular to the experience of the wrongfully convicted is preoccupation with the facts of their case. Doing everything they possibly can in their power to have their case known and be heard. All of the interviewees in some of the similar statistics that I've been looking at describe how they've become absorbed with these details. And some of the people that I've worked with and met with personally have told me a very similar idea. They pore over their transcripts and their court documents, their legal files, and they work with family members to try to do everything possible, as you probably would in the same situation if you were innocent, hounding legal officials and following up, writing letters, anything that could possibly help them in a system that is, strictly against them. And so this is all in pursuit of exoneration at the end of the day. Now here's the problem, folks, with regards to a policy response post-conviction exoneration-wise. When a wrongful conviction has occurred, the wrongly convicted have very, very few levels of recourse available to them in order to rectify the miscarriage of justice. Presently, the methods to redress that include conviction review through our criminal code, commissions of inquiry, and compensation. Now, the conviction review under our criminal code allows individuals to maintain that they have been wrongfully convicted and apply for a review of the circumstances of their case to be heard. Now, this is undertaken through the Criminal Conviction Review Group of the Department of Justice, which is staffed by legal counsel. And the criteria for that is that they must have exhausted all other appeals in these cases through the courts, and that there are, new matters of significance not previously considered by the courts. And so the fact that there is such a strict criteria, very few reviews are completed in any given year, and the process is not only lengthy, but it tends to be quite costly. As you can imagine, if an individual is tasked with exhausting all other appeal options, that often involves hiring an appeal lawyer, which is extremely costly. And once that's been done, they're still looking at applying under this review board. Now, the commissions of inquiry are also considered, as I said earlier, folks, a means to redress miscarriages of justice. So in theory, they have been used toward this end, but in practice, it's not particularly accessible. They tend to occur infrequently. They take many years to complete. And, even when this type of misjustice has been identified, it often sits on our government's desk for way too long. And that's one of the things that we are trying to, patiently, trying to, guide this through, because we do need an independent criminal review case board that in a more time-efficient manner can address a lot of these needs and do so for people, rather than their cases sitting on desks identified as a miscarriage of justice and nothing happening for, a year or two at a time. And, one day is too long for an individual sitting in prison for something they did not do. So it is completely unacceptable to, of course, expect a person to wait another year or two, while this happens. And so that's one of the mandates that the Prime Minister here in Canada has given to our Justice Minister, and we are closely following up on this. So my hope is that we'll have an update shortly in the next month or so, but we do need to have this addressed and have a more effective, efficient way for the innocent who are stuck in our prison system to have a way to access these recourses.
Once again, thanks for joining us. We'll see you back here soon with some more educational videos.